Yes, Mr. Chair.
May it please the Court. If I could ask your Lordships to turn to page 312.
In the main bundle?
In the main electronic bundle, yes. So this is the default clause, and it's identical in terms of clauses A and C at least to the clause that was considered in Bunge and Nidera. And if we go through, the introductory line is, in default of fulfillment of contract by either party, the following provisions shall apply. Sub-clause A, the party other than the defaulter shall, at their discretion, have the right, after serving a notice on the defaulter, to sell or purchase, as the case may be, against the defaulter, and such sale or purchase shall establish the default price. So it's common ground that the default price involves the actual sale or purchase against the defaulter. And here there was an actual sale of these particular goods by Viterra to its related company, Glencore, and those prices would have been the default price. Now,
both parties were dissatisfied with it.
Yes.
One said it was too high and the other said it was too low.
Indeed. Indeed. And in that situation, one turns, and that's clause B. Clause B says either party who is dissatisfied with the default price, or if the right at A above is not exercised and damages cannot be mutually agreed, then the assessment of damages shall be settled by arbitration, which then leads you to subclause C, which says the damages payable shall be based on, but not limited to, the difference between the contract price and either, and this is where the tribunal has a choice, regardless of the parties' positions, the default price established under A above, or upon the actual or estimated value of the goods on the date of default established under B above. And the tribunal, although it could have, did not choose to adopt the default price from the Glencore sales, and instead chose to determine the actual or estimated value of the goods. And we now turn to what those words mean, and we say, in the context of appropriated goods, we adopt the ruling of Mr. Justice Lloyd in the caloric, to which I will soon turn, that the goods can only mean the appropriated goods. And we say that for three reasons. Firstly, the tribunal is directed to value the goods, and the use of the definite article naturally suggests it's the appropriated goods. Secondly, the natural meaning of the word goods, the goods, is reinforced by the words actual or estimated. It's difficult to think of hypothetical goods having an actual value. Third, for those reasons, it is not a natural construction of the words the actual or estimated goods on the date of default to refer either to the market value of hypothetical different goods at a different location on the default date, which is what the tribunal did, or, as the Court of Appeal suggested, the price payable under a notional substitute contract entered into on that date on identical terms save as to price, whilst paying no regard to the actual value of the actual goods. sitting in the seller's hands.
Yes, I mean, if it's a buyer's breach, the seller has goods sitting in a warehouse, which no one's taken. If it's a seller's breach, if the contract hasn't been implemented, then the default price presumably ought to be a replacement contract for similar goods, or as close as possible identical goods to that which had been ordered and not provided. So in a buyer's default, there aren't actual goods.
Yes.
But in a seller's default, in your circumstance, the goods mean the goods in the seller's possession.
Yes. So in the situation of the seller's default, which is the case of the caloric, usually you would not expect there to be actual goods, but there may be. And in the caloric, there were.
Right.
Difficult questions may arise in circumstances where the buyer required the goods at a particular time. So the problem with mitigating by concluding the same contract again is that it brings in the carriage period. So in a situation like we had in Mundra, and this is not our case, but in the situation like we had in Mundra, and there was non-delivery by the seller, it's a question whether a buyer who required those lentils in Mundra on the date that they should have arrived is they're required to mitigate by buying something that will arrive in a month's time, or to actually buy in the local market.
Yes.
It all depends on what's reasonably expected on the fact,
Yes.
what a reasonable person on the facts would do to put themselves as nearly as possible in the position they would have been in if the contract had been performed.
But that's absolutely right, my lord.
There would also here, wouldn't there, be a disconnect between a measure under A and the measure under alternative measure under C?
Yes.
If you've got on the one hand the actual price the goods realised when they were sold where they were in India, and then you're comparing that with a hypothetical sale somewhere completely different.
Yes, my lord, that is a point I am turning to. It's a point that was addressed to both courts below, and they decided that the drafters must have wanted, in my phrase, to choose between apples and oranges. And we say that that makes no conceivable commercial sense. So
it's not in every buyer's default case where there'll be actual goods, is it? I mean, you may have a situation where there's a very early anticipatory breach by the buyer,
yes,
where the seller's gone short and is still out in the market looking for goods to satisfy the buyer's order.
yes. So there appropriation happens usually on shipment, and so pre-shipment there will have been no appropriation, and the buyer may well simply, the seller may simply look for a replacement contract on the same market. So if I could turn to the caloric, which is at page 160 of the electronic bundle. Is that right? That's not right. I apologize, my lord. 878. Sorry. 878.
Thank you.
This is a decision that was cited to both the judge at first instance and in the Court of Appeal. For your Lordship's reference, it is discussed by Lord Justice Popperwell in paragraph 62 of the Court of Appeal's judgment at page 160. That was the reference. So, if your Lordships have page 878, on the left-hand column in the middle of the page, we can see that there is a default clause, and the relevant language appears in the second sentence of that, so second line of that, where damages shall be based upon the actual or estimated value of the goods on the date of default. And what had happened in this case is that there'd been non-delivery by the seller. This was a sale for CIF Beirut. Once the vessel had arrived, the port was closed because of troubles and then a civil war in Beirut. And demurrage was accruing for the account of the buyer. The seller waited for 2 weeks and then resold the cargo with the vessel leaving Beirut. That was found to be a repudiatory breach, and the seller was in default. The tribunal found for the buyer but awarded nominal damages on the basis that the value of these goods would be less than the contract price. And if we turn to page 880, we see the default clause again at the left-hand column. Yes. So your lordships have the default clause, and after reading the default clause, on the right-hand column, Mr. Justice Lloyd says, in the present case, Lorico, which is the buyer, did not buy in against Messrs. Pagan, so the first sentence does not apply, but the third sentence does. What is meant by the damages being based upon the actual or estimated value of the goods? And if I could ask your lordships to read the next 3 full paragraphs with apologies. Yep.
Yeah.
So as you lordships will see, Mr. Justice Lloyd was faced with 2 options. The seller's counsel, Mr. Hallgarten, saying that the goods meant some other goods of the same description, which mirrors what's being said against me by my learned friends. And Mr. Johnson, for the buyers, said it means the goods actually on board the caloric.
The point is that these are the goods that the buyer would have got had the contract been performed.
Yes.
It's those goods that had to be valued.
That's right. And because of the situation in Beirut, there would have been so much demurrage accrued on these goods that the tribunal could easily have found that the goods had no value.
Yeah.
Now,
Yeah. And the distinction drawn in the second last paragraph between the situation that the judge was dealing with and the one where no goods had yet been appropriated, I imagine you would say, I imagine you would adopt that distinction.
yes,
as well.
Indeed, to avoid having to go back to this authority, that is my answer to the non-appropriation case. So in the appropriation case, Mr. Justice Lloyd said at once that he preferred the approach that the goods meant the goods that had been appropriated to the contract, and we commend that decision to your lordships.
The other interesting thing in the second sentence of the penultimate paragraph, when he's weighing up the rival arguments, he says, it seems to me that the goods in the third sentence means in this case.
Yes.
So he is realizing he has to interpret the clause in its application to the facts of the particular case, which may have some bearing
Indeed.
later on when you come on to the appellant's appeal.
Yes, and that feeds directly into what my Lord Reed said, that Mr. Hogarten for the buyers had reminded the judge that the default might have occurred before appropriation, and he says that is no doubt true. In such a case, the goods would have to bear a wider meaning, namely goods of the same contract description. And then this is the key. But that is no reason for applying the wider meaning where the goods have in fact been appropriated. And that is what the Court of Appeal did. They did that.
Which makes it rather pointless to ask a very general question. What does a contractual term mean in all circumstances?
Yes.
Where here, quite clearly, the default clause will have to be applied in very different circumstances, and therefore the particular circumstances of the default are relevant to the application of the clause.
Yes. To address a point, Lord Justice Popplewell distinguished this decision on a passage on the next page, 881, the second full paragraph, where Mr. Justice Lloyd says, how then was the Board of Appeal to arrive at the value of the goods? There were several ways, and he highlights different ways where the Board of Appeal could have come to a zero value. And perhaps I could ask your Lordships just to read that paragraph, just to be fair to the Court of Appeal.
Yeah, and perhaps the paragraph after is also material.
Yes. So, basing himself on the second full paragraph of the left-hand column, Lord Justice Popplewell said that the tribunal could have arrived at the decision it did based upon the notional contract analysis. That may be true, but that is not the reasoning of Mr. Justice Lloyd. And what Mr. Justice Lloyd accepts is the argument of Mr. Johnson that the goods in an appropriated, where in a case where the goods have been appropriated, it means those appropriated goods. And he repeats that in his conclusion at page 882. Right at the top, about 4 lines down, Mr. Justice Lloyd says, it is altogether different when the language does not so permit. In the present case, for the reasons which I have already given, I have no choice. Where goods have been appropriated to the contract, as they were in this case, the goods can only mean the goods so appropriated. If I could ask your Lordships to turn back a page to 881, Mr. Justice Lloyd refers to an earlier decision of his, which I'm going to take you to, in the right-hand column, right at the top. And he says, I was referred to an earlier decision of mine own in the Eurometal. In that case, there was a default by buyers in failing to take up documents. So that was a non-acceptance case like ours. I'll take you to that case, but there is a very helpful summary in this paragraph, and perhaps I could ask your Lordships to read that paragraph. So this is Mr. Justice Lloyd explaining what he decided, he himself decided in the Eurometal, namely his decision was based on the fair market value of the goods where they lay. He picked the 126 figure because that was the fair market value of the goods where they lay. It's about 1/3 of the way from the bottom of that paragraph. And if we could now turn to the Eurometal case, which is at page 548 of this bundle.
I think the significance was they couldn't claim on the particular facts the demurrage separately, wasn't it?
Well,
Or have you shown us anyway?
yes,
Sorry, which page?
548. So this is a case in which there was a sale, CIF One Safe Port, West Coast, Italy, and you see that at page 550, right at the bottom, under the heading Special Case. And perhaps I could ask your lordships to read from the bottom of page 550 to the top of 551, that one paragraph which sets out the facts. If we could then turn to page 556, which is where Mr. Justice Lloyd starts his analysis. The default clause appears in the top third of the page, and the relevant passage comes about sort of a third of the way down, where he talks about default shall be settled by arbitration, and such damages in the absence of special circumstances shall not exceed the difference between the contract price and the market price, or its equivalent found by the arbitrators or the Court of Appeal on the date of default. So it's not identical to our clause, but it's a predecessor perhaps. And if I could ask your lordships to read the next two paragraphs, which
But what I think they were trying to do was get the value of the demurrage back by sort of building it into the
Yes.
follow-on
Yes.
substitute contract.
That's right. So what the tribunal had done is they had awarded the difference between the contract price and the sale price simpliciter, 114. And what Mr. Justice Lloyd said, well, you can't do that because you're obviously missing out the demurrage. But, and the issue that causes difficulty in the Court of Appeal is that the figure that Mr. Justice Lloyd picks is 126. Now, 126 happens to be the effective resale price, the actual price under subclause A in our case. It is also what the tribunal found to be the market price. And so Lord Justice Popplewell says, well, oh, that's consistent with my notional contract theory. The problem with that is that's not the basis upon which Mr. Justice Lloyd came to his decision. As you've already seen from his summary in the caloric of this decision, and indeed, and again, if I can impose upon your lordships to turn to page 557.
I mean, just before you go there, the very last sentence of the last full paragraph is interesting. Nothing in the clause entitles the Board of Appeal to award the seller any loss in excess of the ordinary measure of damage.
Yes.
So it's compensatory damages and nothing else.
That's indeed, and that's what we have said.
Yeah.
And then if we turn to page 557,
Yes.
Mr. Justice Lloyd repeats that because there were various arguments. And then if we go 4 lines down into the first full paragraph, he says, but putting that on one side, the buyers were still only obliged to make good the seller's loss on resale. What is meant by loss? It means loss which is not too remote in the law. In most cases, such loss would be represented by the difference between the contract price and the resale price, but here the resale price contained hidden elements, and then he explains that. And he says, but for that obligation, the price would have been 126. And then right at the bottom, he says, the sellers can recover the difference between the contract and market price, but no more. In the next paragraph, I could understand an argument that the market price for this barley must take into account the liability for accrued demurrage, that is to say $55,066. But no such argument was advanced by counsel for the sellers, no doubt because of the express finding that the market value of the barley, where it lay in La Spezia, so that was the discharge port, was 126. It seems to me to follow that the difference between 126 and 132 represents the maximum loss recoverable under this contract. And again, skipping the next paragraph, I would therefore answer the questions of law in the award as follows. Yes. And 2, the maximum entitlement of the sellers to damages is the difference between the contract price and the market price for the cargo as it lay at La Spezia. So although that $126 figure happened also to be the effective resale price, shall we call it the default price, Mr. Justice Lloyd, adopted it because it was the expressly found market price. And the Court of Appeal in paragraph 61, page 160 of the bundle, was wrong to dismiss the Eurometal as authority for that proposition. I now turn to the point that my Lord Legate raised about consistency with subclause A. As we have seen, subclause A provides a freestanding mechanism for valuing the goods that either have not been accepted or have not been delivered. And even if both parties disagree with that valuation, the tribunal retains the discretion to adopt it when carrying out the valuation under subclause C. But both at first instance and in the Court of Appeal, and indeed my learned friend's case in this court, is that the alternative to the default price provided for in subclause C is a pricing on a completely different market. On the facts of this case, any default price, and I believe this to be common ground, would have been a sale in Mundra where the goods were. But it is said that that price has to be compared with the price of CNF FO, which on the facts of this case involved buying or notionally buying in Vancouver and shipping to Mundra. And we say that no commercial logic has ever been proposed, or indeed can be proposed, for the drafters of this clause, being practical GAFTA traders, to have wanted to impose upon a tribunal the job of comparing two different markets, yielding potentially two very different figures, as we see in the facts of this case. So we say commercial...
You're looking to see what you could sell the goods for. You don't look to see what you could sell them for in Vancouver.
Yes, indeed. So then it may be asked, well, why have two measures in subclause C? And that's to guard against precisely the situation that has happened in this case. It was a related party sale. And my clients maintained before the arbitrators, and still do maintain, that it was at undervalue.
Mr. Carey, I'm a relative newcomer to Clause 25.
Yes.
But I'm puzzled as to whether C, when it says the damages payable shall be based on, is talking about, is collecting together, if you like, the damages if they go down the subclause A route and simply take the resale price.
Yes.
Or alternative, the damages they go down the subclause B route, in which case they look at the estimated value of the goods on the date of default established under B. I think you're saying, well, the arbitrators can actually themselves choose the default price.
Yes.
Would they do that otherwise than because the default price is the best evidence of the value of the goods? And if not, what yardstick does the arbitrator apply in choosing between A and B, or rather A and when conducting a damages exercise under C?
Well, it's clear law, certainly.
Well, I thought there'd be some law on it, which is why I'm asking for your help.
So, clear dictum of Lord Sumption in Bungie and Nidera at paragraphs 28. I hope if you just bear with me, my lord, I'll take you there.
Don't let me take you out of your course if we're going to get to it.
No, it's, this is...
28 is 532.
Yes, and 533 is the relevant page. It's subparagraph 3.
Yeah.
Which says subclause C provides for two alternative bases of the assessment of by the arbitrators. The first, which applies if the default price has been established but not accepted, is the difference between the default price and the contract price. That's the clause A price, my lord. In other words, if the injured party has gone into the market and bought or sold against the defaulter, the arbitrators may accept that the default price should be used to calculate the damages, notwithstanding the objections of one or other or even both of them.
Well,
I mean, might the arbitrators have decided in this case that there was really no evidence of any market value for the goods in Mundra other than what they were actually sold for, even if it wasn't an arm's length sale?
Yes.
And therefore, as it were, rejected both the Vancouver price and the local market price based on small quantities, and just settled for the default price because there was nothing on the evidence provided. They couldn't do better.
They would have been perfectly within their rights to have done that. The problem that my learned friend's construction raises is the problem referred to by my Lord Briggs, is there's no yardstick to measure two very different.
No, and the language says the damages you pay is either the default price or the actual or estimated value of the goods established under B, i.e. established in the arbitration.
Yes.
So it suggests that the arbitration is only going to establish the estimated value of the goods, and the choice for damages is between the default price and what is established in the arbitration. If there's no arbitration, obviously it's the default price. If there is an arbitration, then prima facie it'll be what the arbitrators conclude is the value of the goods. It doesn't look to me as if the concept is that in the arbitration you'd be sort of tossing up and saying, well, do I like the default price or the estimated value? I mean, I can see Lord Sumption says the opposite. I just find it quite difficult to get what he says out of the language of the clause.
Well, bearing in mind that this is a trade body drafted clause, it, I think, has been accepted. Is, I think, common ground between the parties. No doubt my learned friend will correct me if I'm wrong, that once you get into the arbitration, as Lord Sumption explains in paragraph 28, subparagraph 3, on page 533 of the electronic bundle, the arbitrators have carte blanche to choose between valuing the goods themselves, however they can, or simply adopting the default price. And one reason might be, as fell from my Lord Legate, that they're just not happy with the evidence that they've got about the market, and that you have to do the best you can, and this is what you'll have to do, and both parties have to lump it.
It's where in C they refer to the damages payable. What they're talking about is the damages payable under the assessment settled by arbitration.
Yes.
So once you get into C, it's telling the arbitrators what to do.
Yes.
And that you get the two options: accept the default price against the objection of the parties, or fix it yourself.
Yes.
In terms they're stated. Yeah.
And that's why the absence of a yardstick or any commercial rationale, A, from comparing these two disparate markets, and B, how the tribunal is to go about its job in comparing these apples and oranges and picking amongst them, is one of the reasons why that cannot be the correct construction. The other, we see Lord Toulson at page 541. And this is in paragraph 59, near the letter E, my lords. And he is here discussing the subclause A, the default price. And he says, I prefer the former interpretation because it seems most likely that the purpose of this part of the clause is to provide a surrogate for the valuation of the contract goods, which presupposes that they are identical. But the point is academic. So the point of the actual resale is to provide a surrogate. Now, perhaps part of the background is that common law generally, you can't look at the actual sales that the innocent party has conducted to determine its loss, because under section 50 subsection 3 and 51 subsection 3 you look at the market.
They can be evidence.
They can be evidence, indeed. Yes. They can be evidence, but
it's not determinative.
They can't, yes. Whereas under the default clause, it can be determinative either if the parties agree, or if chosen by the tribunal despite the parties' disagreement. And even if both parties, as in this case, say, no, that price is...
a much simpler way to arrive at a figure.
Yes. So that's what it's... So we say the better reading is that subclauses A and C, A, they're valuing the same goods because they refer to the goods, and it makes no rational sense that they should be valuing them in completely different conditions. There is some authority on this, And this is from the decision of the House of Lords in Bramer versus Vanden, my lord, and this appears at page 498. I should say at the outset that this was an obiter decision because damages did not fall to be determined in that case, but their lordships, all of them, at least 4 of them, addressed it. So page 510, this is in the speech of the Viscount Dilhorn, and this is relevant only at the very bottom of the right-hand column. Viscount Dilhorn says, we were asked to construe the sentence in clause 26 in the event of default by sellers entitling buyers to damages. Such damages shall be based upon the actual or estimated value of the goods on date of default. I don't need to take any more, but that is the only place in the report where the clause appears. And the question in this case is, we can see at page 506, was the date of default for what I will call valuing under subclause C.
Where do we see that?
Sorry, so this is the left-hand column on 506, second full paragraph.
Oh, I see. The choice lies between.
Yes, the 10th of July the 10th, 1973, which was the last day for performance, or July the 11th, which was the first day on which the sellers could be said to be in default.
Fast-moving market.
And he says there was a Court of Appeal decision that chose the former, and there was a practical difference because there'd been a market movement between the 10th and 11th. So Lord Wilberforce, starting exactly halfway down, if I could ask your lordships to read from the word taken as it must be as a whole, clause 26. Do your lordships have that? Left-hand column, halfway down. And the key passage, my lords, is right in the middle of the passage that I have asked your lordships to read, where Lord Wilberforce says, what decides me in favour of the latter date, July 11th, is the provision allowing the buyer to buy in on the market, that this right could not be exercised until July 11. And then on the right-hand column, Lord Wilberforce says, to hold that the damages are to be fixed at the price at which he could first have bought makes the clause consistent and workable. Now, the issue was different, but the necessity to construe subclauses A and C consistently so they don't lead to disparities is obvious. The same point is made by Lord Salmon at page 518. and it's the first full paragraph on the left-hand column. Three lines down, he says, assuming that the breach did occur on July 10, still the buyers could not have bought on the market until July 11 for shipment and appropriation after the market closed, but before midnight July 10 would have been a perfectly good execution of the contract. If the market price had fallen on July 11 to the contract price, the buyers would have suffered no damage and should recover none. If, on the other hand, the market price had risen on July 11 above the market price on July 10, it seems only just that the buyers should have been fully compensated for their loss. So again, requiring consistency between the subclause A and subclause C.
You can say in this case that the board has decided the date of default is the first day sellers could actually sell these goods.
Yes.
Rather than when they declared default.
That's right. That's right. But one of the reasons why Lord Wilberforce said that, he said, what decides me is because otherwise you get valuation on two different dates, and that leads to disparity between subclause A and subclause C. And Lord Russell agrees at page 520. It's the penultimate full paragraph of his judgment, and 4 lines down, Lord Russell says, I was at one time attracted by the theory that a few seconds before midnight on the 10th there would have been no time left to prepare whatever document was necessary, therefore default would be on the 10th. In the end, I'm persuaded to agree with my noble and learned friend Lord Salmon that it is more in accordance with good sense to coordinate this question with the ability of the buyer to go into the market for the first time on the 11th in order to redeem his position as best he may. I now, still within the heading of construction of subclause C, propose to turn to the commercial context and business common sense. Your lordships will have, if I could trouble you to open up the Respondent supplemental bundle, which we opened up prior to the short adjournment. The lordships will have at page 2 the GAFTA web page. This is the home page of the GAFTA website. And really what I want to show your lordships appears at page 5. So
6 reasons to join GAFTA, is that it?
Pardon?
6 reasons to join GAFTA,
Yes,
is that
exactly.
what you're saying?
6 reasons to join GAFTA. I'm not being paid to advance their cause here today, but one of the reasons that is said is that contracts. So GAFTA develops the standard form contracts on which it is estimated 80% of the world's trade in grain is shipped. GAFTA members can also become members of GAFTA's committees to ensure that these contracts remain current, party neutral, and reflect trade practices. I should.
To us looking at this material. There's no objection to us looking at
I might object on the basis if it's factual matrix, then it's inadmissible because there's no factual findings.
I mean, normally we just look at the award.
Indeed, but I'm simply trying to provide information as to what GAFTA is. This, again, if there's an objection, I will put it aside. I don't need to rely on it. But I think it is important for the court, those who have not practiced in that area perhaps, to know what GAFTA is and what types of people are members of GAFTA and who sits on their committees that draft these contracts. Because as Lord Toulson says in Bungie and Nidera, what you're seeking to do is to get the intent of the drafters. And it's one thing for the drafters to be city lawyers. It's another thing if they are traders.
We don't know any of this.
I will move on, my lord.
It would be astonishing if GAFTA traders didn't run their standard form contracts past a lawyer.
Right.
They'd be very unwise not to do so.
Perhaps that isn't my strongest point. The stronger point is that this is designed for use by GAFTA traders between themselves.
Yes.
And as a result, one would expect them to create a neutral contract, because the buyer and the seller will usually be either GAFTA members or people who use GAFTA contracts. So there's no reason, unlike, for example, with BIMCO, which is a ship owners organization, for them to favor one side or the other. Also, the drafters do not know, prior to having concluded a contract and performed it, whether they are going to be the defaulting party or the innocent party. It's not that they intend to default. Default sometimes happens through no fault of their own. And what that means is it's reasonable to presume that they would have intended that the defaulting party should pay fair compensation, but no more than fair compensation, that the innocent party should be fully compensated but not enriched. And the logic here is the logic that we find in the common law, which is the authority I was going to take to you earlier, is at page 492 of the authorities bundle. This is the main electronic bundle, my lords. I would ask your lordships to keep open the respondents bundle as well, because I will be turning to that.
We can't do that, I'm afraid. Well, perhaps Lord Briggs can, but I have to go too.
You'd have to split the screen.
Yes, well, I don't mean, I simply mean don't close the PDF.
So page in the ordinary bundle?
490.
490, thank you.
Okay.
So,
It's Barrow and Arno.
yes.
Right.
Now, this is a case, as my learner friend points out in his responsive case, it's a conversion case. And it was a question of valuing the loss suffered by the claimant. And it's the decision of Lord Chief Justice Tyndall. And the passage that I wish to take your lordships to is 492, right in the middle of the page. And it's the first full paragraph starting, "It remains for us to consider what is the proper measure of damages to be recovered." Your lordships have that. And the key passage is, where a contract to deliver goods at a certain price is broken, the proper measure of damages in general is the difference between the contract price and the market price of such goods at the time when the contract was broken, because the purchaser, having the money in his hands, may go into the market and buy. So if a contract to accept and pay for goods is broken, the same rule may properly be applied, for the seller may take his goods into the market and obtain the current price for them. Now, my learned friend, in his supplementary skeleton case, says this is an irrelevant case. It's a conversion case and it's irrelevant. We're somewhat surprised by that, and if I could ask your lordships to turn to our supplemental bundle, page 50. So this is the cover page to McGregor on Damages, 21st edition. And if I could ask your lordships to turn to page 52. And the editors of McGregor, under the heading normal measure, state that the normal measure of damages as stated in section 50 subsection 3, thereby incorporating the common law as stated in Barrow and Arno, is the contract price less the market price at the contractual time for acceptance. This represents the amount the seller must obtain to put themselves in the position they would have been in had the contract been carried out, since they can sell the goods in the market. And if when convenient, your lordships can go back to page 43. This is the 12th edition of Benjamin, published this year. And at page 45, under the, I'm only taking out, there's a passage, I'm taking you to page 45 because you will need to look at this later, so we might as well look at it now, where it says the rules of mitigation of damages are closely associated with the market price rules found in sections 50 subsection 3 and 51 subsection 3 of the Act. That's all I need you your lordships to look at. And then at page 48, under the heading unavailable market, just the first sentence, prima facie rule, the market price, the normal rule stated in section 50 subsection 3 incorporates the common law established before the Act. And it cites at footnote 5 to 8 Barrow and Arno, and in particular the passage at page 610 that I put your lordships to. So we say that this is the fundamental philosophy behind the quantification of damages under the Sale of Goods Act.
What about Mr. Justice Robert Goff's analysis in the Eleni D'Amico? Did you dissent from any of that?
No, I mean, it's a long judgment,
well,
and it deals
dealing with what the basis of section 50 and section 51, how it relates to mitigation. Have a look at it overnight.
I will, if I may return to your lordships, I will be making some further submissions on mitigation. And if we could just for your reference, Lord Sumption, at Bungie at paragraph 16, page 528, explains that the sale of goods adopts the common law principles that had been established at the time the 1893 Act was incorporated. It's page 528.
Para 16. Yeah.
Para 16. And if we could turn now back to the
He also explains in 17 that it's based on mitigation of loss.
Yes. So, and in fact, I'm going to seek to show that, but that perhaps I don't need to do so. And we have a modern iteration of Chief Justice Tyndall's statement in the speech of Lord Scott at page 646.
This is the golden victory.
This is the golden victory, my lord. And perhaps it's best to start at 645. So it's paragraph 34. And Lord Scott, who was in the majority, was discussing the date of breach rule. And he says the assessment of the date of breach rule is particularly applicative for cases where a contract for the sale of goods in respect of which there is a market has been repudiated. The loss caused by the breach to the seller or the buyer, as the case may be, can be measured by the difference between the contract price and the market price at the time of the breach. The seller can resell his goods in the market. The buyer can buy substitute goods in the market. Thereby, the loss caused by the breach can be fixed. Now, below, Lord Justice Popplewell, at paragraph 55 of the Court of Appeal judgment, page 158, said that Sharp's construction, which is the construction I commend to your lordships, offends rather than gives effect to the compensatory principle, because it compares apples with pears and is not a measure of loss of bargain. We say, with respect, the learned Lord Justice is wrong. It is valuing hypothetical goods based on a notional contract where you have, staring you in the face, actual goods in an actual market with an actual value that does not give effect and indeed offends the compensatory principle.
Yes, I mean, the difference, if it's the buyer who is the innocent party, he may have lost the benefit of the contract.
Yes.
And you can see in that circumstance, recontracting on identical terms
Yes.
would be a mitigatory measure.
Yes.
But it seems to be completely irrelevant to the seller, who is the poor chap left with the goods that he thought he'd sold.
Yes. At the very basic Robinson and Harmon point, if one looks at the post-breach situation of the innocent seller, it should have received the price, let's say $100. He doesn't have the $100, but he has in his hands an asset which is worth $70 or $150. That's how you measure how his financial position has been harmed by the breach.
A rather odd passage, I thought, in the Court of Appeal's judgment at the start of paragraph 55, where it looks as though Lord Justice Popplewell's accepting your proposition for a moment.
Yes. If I may just be given a moment. Now, if we go to Bungie and Nidera at page 532, page 532, this is in the judgment of Lord Sumption, paragraph 27. Sorry, apologies. 26, I apologize.
I'm so sorry, can you give me a page number?
Yes, 532, my
Thank you.
lord. And at line E, when he's addressing a submission made to him, Lord Sumption says, however, I would accept a more moderate version of Mr. Rainey's presumption. A damages clause may be assumed in the absence of clear words not to have been intended to operate arbitrarily, for example, by producing a result unrelated to anything which the parties can reasonably have expected to approximate to the true loss. And we say that the true loss isn't some legal fiction or something requiring great legal acumen. Any trader knows what his loss is. And any seller who is left with goods on its hands when it should have got a pot of money knows that his financial situation is worse by the difference in the value of the two in his hands.
If there's a market.
If there's a market.
Yes.
Well,
I mean,
normally, I'll just caveat that. I mean, if there isn't a market where the goods are, then one has to look for the nearest market. And then with cases like the Texaco Melbourne, one has to construct a value based on nearest markets, but that isn't an issue in this case. There is a domestic market.
I mean, if you're the trader, you might simply look at the difference between what the price that you were going to get and what you actually got for the goods.
Yes.
But the common law adjusts that by saying if the price you actually got, you could have been more or less if you've gone into the market, then you're treated as if you had gone into the market.
Indeed. And Lord Toulson at page 541 at paragraph 61, right at the bottom at the letter J, he's looking at various options, and in doing so, he says that the first construction would require the tribunal to adopt a blinkered approach to the facts, which would place the buyers financially in a far better position than if the breach had not occurred. This is most unlikely to have been the drafter's intention. It is far more likely that the drafter had in mind the usual situation of non-delivery or non-acceptance of the goods for which there was an available market. So Lord Toulson is saying it's much more likely that the drafters of the default clause, because that is what he was considering, would have intended to avoid overcompensation. Just for your...
Well, he also expressly rejects the argument that the clause precludes the operation of the common law principle of mitigation of
Yes.
loss. So I took that to be a holding in Bungie that you do apply the ordinary approach to looking at
Yes, which was...
how the mitigation principle applies when there's an available market.
Indeed, my lord. And we have set out the effect, the overcompensatory effect on the facts of this particular case on page 129, paragraphs 100 and 101. I don't ask your lordships to turn it up now, but in our printed case, we have set out the overcompensation, and indeed, we say even adopting the related party transaction, there should be zero compensation for the peace contract, and yet over $900,000 has been awarded. And as I mentioned, I think this morning, this doesn't always work in the innocent party's favor. So if we consider a hypothetical where the international market price for lentils is $100 and the contract price is $100. But because of a bumper lentil harvest in Gujarat, it's now $50 in the local market. The same facts apply. The seller is left with goods worth $50 a metric ton on the local market. That's all it can get. On my learned friend's theory and the Court of Appeals theory, you forget about the value on the local market, you look at the value on the international market, which is 100, so the seller gets zero damages. But on any commercial, rational, logical view, it has suffered $50 per ton of loss.
Well, that assumes it has to sell into the local market, but I suppose you're saying once you've cleared customs, maybe you don't have an alternative.
Well, and that is one point. The other point is, even if, let's say, you could get over the hurdles, and I suppose, God help any trader trying to get goods out of any customs in anywhere in the world, but then they would have to ship them out. That's an additional cost.
Yeah. But, I mean, taking the fairly extreme example which you've given, if you can get 100 per ton internationally, and you only get 50 per ton in Gujarat, you probably do want to ship them out.
Yes, but it may take you 6 months, it may take you 9 months. You may
Sure,
never
there are all
get
sorts
it
of other calculations. I fully understand that.
Yes, but what the law does is it looks at the market where it is. And
Well,
if you do
Prima
that,
facie.
prima facie,
Yeah.
yes. Now, I now deal with arguments advanced in my learned friend supplementary case at paragraphs 11 and 35(2). We don't need to turn it up, but he says that Sharp should not get the benefit of the increase in the market price of the goods because it was entirely fortuitous and did not arise by virtue of the CNF-FO terms of the contract. We say that...
Well, that's true every time the market rises and falls.
Indeed, I'm not sure I need to say more than adopt what my Lord Legate has said, but I was going to say that it's like the weather. Yes, you can't predict it, it's fortuitous, but it affects the value of what you have in your hands. So for those reasons, we say that the proper construction of subclause C, when applied to a case where goods have been appropriated, is that the goods refer to those appropriated goods. I now move to my third heading, which I think will be brief, and that's how the default clause and subclause C in particular applies where no goods have been appropriated. And your lordships have seen what Mr. Justice Lloyd had to say about that, and he said it's no doubt true that the goods will have to have a different meaning, but it would have to bear a wider meaning, namely goods of the same contract description. And we accept that and we commend that to this court. Now I propose to turn to my fourth main heading, which is Bunge and Nidera.
Could you just give me a reference to Mr. Justice Lloyd again?
Yes, my lord. It's page 880.
Thank you.
And it's the second column. Now I need to address Bunge and Nidera, which is the authority that both Mrs. Justice Cockrell and the Court of Appeal relied on to find on this issue in my learned friend's favour. And we have 4 reasons we say that Bunge and Nidera does not answer the question before your lordships. Firstly, and it's conceded that those statements were obiter. Indeed, Lord Sumption himself, in paragraph 28 at page 532, letter J, expressly states that this is obiter. It says, just above the letter J, he says, detailed analysis of the way it, as in the default clause, works does not affect the outcome of this appeal, and the argument on the point was largely foreclosed by the way the case was put to the arbitrators. But given the importance of the GAFTA default clause, it is right to deal with it. And then he sets out his various propositions that we have looked at. As your lordships know, that case concerned a prematurely terminated contract which was completely executory.
By the seller, wasn't it?
Yes, by the seller. That there'd been a prohibition issued by, or I think there was a publication that there would be a prohibition coming in by the Russian authorities, and the seller purported to terminate prior to that prohibition coming into place. And the only issue that remained before the House and was before the court and was decided by the Supreme Court is the applicability or not of the golden victory compensatory principle. It was said by the buyer that the golden victory compensatory principle did not apply to to contracts which were not installment contracts, or alternatively were excluded by the terms of the default clause. Therefore, the default clause played no part whatsoever in the decision in Bunge and Nidera. So one answer to Bungie and Nidera is to adopt what my Lord Reed said in One Step and Morris and Garner, citing the Earl of Horsbury in Quinn and Leatham, a case is only authority for what it actually decides. And Bungie and Nidera did not decide this point. Second, Bungie and Nidera, the dicta in Bungie and Nidera are equally consistent with my case as they are with my learned friends when the facts of Bungie and Nidera are borne in mind, i.e., no appropriated goods, completely executory contract. On those facts, we accept the notional contract analysis. Again, we would ask your lordships to bear in mind the full passage from Quinn and Leatham from the judgment, the speech of the Earl of Horsbury, and that appears at page 974 of the authorities bundle. (974), my lord. Cap 31. Yes, and it's quoted on page 133 of our printed case as well, paragraph 112. And it appears right at the middle of page 974, where His Lordship says, before discussing the case of an Allen flood, he says, I wish to make, there are two observations of a general character which I wish to make, and one is to repeat what I have very often said before, that every judgment must be read as applicable to the particular facts proved or assumed to be proved, since the generality of the expressions which may be found there are not intended to be expositions of the whole law, but governed and qualified by the particular facts of the case in which such expressions are to be found. And that's followed by the sentence that my Lord Reed cited in One Step. The other is that a case is only authority for what it actually decides. Fourth, and this may well be the same point, there's no indication that either Lord Sumption or Toulson had facts of this case or similar cases in mind when propounding the principles or construing the default clause.
And they're not going to get to this, but what do you say is wrong with the analysis of the clause made by Lord Sumption?
Well, it applies pre-appropriation.
Well, he makes a number of general comments about how the clause works.
Yes.
And many of them are in the context of actual breach, because he's referring to the Sale of Goods Act.
Yes.
I'm not quite sure which parts of this analysis you say are wrong.
Which you were trying to explain away. I mean, it all seems perfectly reasonable to me.
It's whatever part
Well, perhaps you could show us the
persuaded the Court of Appeal.
You tell us which part you disagree with.
Yeah.
Well,
Which parts do you need to explain away, as it were? I mean, I think sort of dealing with it in the abstract.
I think you accept the reasoning in the context of an executory contract where the seller is in breach and there are no appropriated goods, because what the buyer has lost is the benefit of the contract. And in that context, he can't get more back than a contract on similar terms.
yes. Perhaps I should put it this way. If read in accordance with the dictum of the Earl of Horsbury, there is nothing objectionable about Bungie and Nidera. But the problem is not with Bungie and Nidera, the problem is with the Court of Appeal that didn't read it, despite this dictum having been cited to it in that context. Lord Justice.
Well, if there's two or three key passages which they rely on, it might be helpful if you pointed them out and then explain why they don't lead to that conclusion, if that's your argument.
Yeah, if your Lordship would bear with me. Your Lordship.
Well, it's really the second half of 4, isn't it, on page 533 to 4? Lord Sumption's second difference from the common law paradigm.
Yes, I mean, if your Lordship will just bear with me for a second.
I don't see that.
Isn't it? Well,
That's problematic, is it?
not with the market price of the goods and the actual or estimated value.
So,
Which the market is different, but comparable goods with a different origin or shipment date. I mean, I can see
so
that.
at
That
paragraph,
may sometimes be the case.
That may be so, but there's no appropriation.
Yes, when I read that, I did put a question mark beside.
Yes. I mean, miss how much emphasis you place on may.
Well, sometimes you look at, if you're trying to get a market price and the best you've got is from slightly different goods or something, or you might take that as evidence and adjust it if you need to.
Yes.
I'm not sure he's saying anything other than that.
no. Perhaps if your Lordship will bear with me, but the issue arises.
Well, it strikes me that what's being said at 4, at the end of 4, is a distinction without a difference. That you're simply using the market price of comparable goods as a surrogate for the market price of fee goods.
I think that's all he's saying.
Yeah.
So if we can go to the Court of Appeal's decision, there is, or perhaps I could revert to that question, if I may, and I'll come back to your Lordships on precisely which passages, but it's simply the use that was made of language which was applied in the situation of a prematurely terminated contract to a substantially performed contract, and where goods had been appropriated which are wrong.
Yes, and in a context of a judgment where the compensatory principle applies and the mitigation principle applies, the use of that formula seems to be contradicting those principles, if you apply it in the circumstances of your client's case.
Yes, indeed, my lord. So if we could turn to paragraph 85 of Lord Toulson's judgment. And that's at page 546. And Lord Toulson here is addressing the fundamental compensatory principle, and he says at the letter F, 546, the fundamental compensatory principle makes it axiomatic that any method of assessment of damages must reflect the nature of the bargain which the innocent party has lost as a result of the repudiation. Now, that just shows they're talking about repudiation there, but also it reaffirms the commitment to the compensatory principle.
And what he's saying is that the buyer who's been subjected to an anticipatory breach is entitled to have the benefit of the bargain which he had, and also the disbenefits, because if that substitute contract is in place and something goes wrong, as it did in Bungie, then he has to live with that happening.
Yes.
Yeah. But, I mean, obviously, if the nature of the market is one where there are uncertain contingencies, then that'll be reflected in market value.
Yes.
Yeah.
Yeah.
My lord, if I could take your lordships to the Court of Appeal's judgment at page 157, my lord.
paragraph.
It's right at the top of the page, which is actually paragraph 49, and Lord Justice Popplewell says...
Before we go, I'm sorry to interrupt you, but just before we go to that, I presume you take issue with the last couple of sentences of 48.
Yes. Yes.
And this is the problem that Mr. Justice Lloyd identified in the case you took us to earlier.
That's right. So if we go down about 8-9 lines from the bottom of paragraph 48, Lord Justice Popplewell says, what was said on the subject was therefore arbiter, but of considerable weight as guidance as to the meaning and operation of the clause. What was said in the context of a defaulting seller, so that the concepts of mitigation contract and a notional substitute sale were of a contract of purchase by the buyer. However, because what was said was advanced by way of general principle, the dicta can be transposed to the context of the present case, where the default is by the buyers, not the sellers, so that a mitigation contract or notional substitute contract is a sale by the sellers. Now, the actual submission that was made to the Court of Appeal wasn't that you can't transpose this because the breaching party is the buyer. The actual submission made to them is you can't transpose it because that was a premature termination of a executory contract. And then at paragraph 49, Lord Justice Popplewell cites certain statements of principle that he says are of direct assistance. And on page 157, and 6th line down, Lord Justice Popplewell says paragraph C of the default clause covers the same territory as sections 53 and 51.3 of the Sale of Goods Act. It quotes Lord Sumption at paragraph 32. And we accept that, which themselves treat as the prima facie measure of loss the common law compensatory measure where there is an available market, which is the difference between the contract price and the price which would have been agreed under a notional substitute contract assumed to have been entered into in its place on the date of breach at the market rate, but otherwise on the same terms. That is what we disagree with. And that's quoting Lord Sumption, because he has elevated a principle which was perfectly logical, applicable, and correct in the circumstances of Bungie and Nidera to a general principle applicable to all cases. So unless I can assist...
That is actually only relevant, isn't it, when it's a seller's default?
Yes, because what the buyer's lost is the benefit of the contract.
Exactly.
And that's where it seems to me there's a complete mismatch here, because the seller's problem is that he's been left with the goods.
Yes.
The buyer's problem is he hasn't got the benefit.
He hasn't got the price.
Yeah. Yes. No, I mean, the buyer's problem is...
He hasn't got the benefit of the
goods.
contract. He hasn't got the goods.
So he has to go and get...
So he needs a substitute contract.
Yes.
All the seller needs to do is flog the good.
Yes. Yes. And in one sense, one can say that's a substitute contract, but it's a substitute contract to mitigate your loss.
Yes, but it's not a substitute contract of carriage from Vancouver.
Yes.
It's whatever is the best way of mitigating your loss, selling in the appropriate market.
Indeed, my lords.
Yeah.
So unless I can assist your lordships further on Bungie and Nidera, I propose to look at the common law, because this is relied on by my learned friend, supporting the Court of Appeal's construction. So at paragraphs 12, 3, 15, and 34.2, and it might be worth pulling them up.
12?
Paragraph 12, subparagraph 3, 15, and 34, subparagraph 2 of my learned friend's supplemental case, which I'm not sure has made it, no doubt my learned friend will correct me, into the electronic bundle. Is it?
Got a separate bundle.
It's a separate bundle, yes. Appellant supplemental written case.
Yes. Oh, it's in the supplemental bundle? Yes.
It's a supplemental written case.
Yes. Supplemental written case, which is in, I think, the appellant supplemental bundle, at page 83. So,
It has got into the supplemental bundle then. Okay.
yes, apologies, that was my mistake. So it starts at page 83, and the first relevant paragraph is at page 87.
I'm so sorry. Page?
Page 87, my lord, of my learned friend's supplemental bundle.
Oh, I see. I'm looking at his supplemental case, which is in it. I've got separately.
Well, if you have the case separately, then that's page 5, internal.
Thank you.
Page 5, paragraph 12.3.
Yeah.
So he says, under the paragraph 12, subparagraph 3, under the general law, the market or current price is based on a notional substitute contract entered into on the same terms as the unfulfilled contract, save as to price. That is said to be the common law, and then that's repeated at page 88, page 6, internal numbering, paragraph 15. And it is said, under the general law, the market or current price is based on a notional substitute contract entered into on the same terms as the unfulfilled contract, save as to price. See Bungie.
Yes, but if you treat section 50, subsection 3 as a codification of the common law, it says no such thing.
Indeed, that's precisely what I was going to move to. And then I think in greater detail at page 95,
Paragraph.
sorry, not 95, so it's actually 93. Is that right? Is it 34.2?
34.2.
Yes, I think. I think I have an incorrect reference.
Yes.
So,
No,
But-
that's right.
but it is helpful at paragraph 34.4, which is at page 95. To see what my learned friends say about the Barrow and Arnold case, and also the Napier and Dexter's case, which I will be taking your lordships to. And perhaps I could ask your lordships just to read what they say, having taken you to Barrow and Arnold. So we make the following points about my learned friend's reliance on the common law. First of all, putting aside what the content of the common law is, this court has to construe the default clause. Now, I've already referred, as to what the content of the common law is, I've taken this court to Barrow and Arno. I've taken your lordships to Benjamin and to McGregor, saying that that forms the basis of the Sale of Goods Act, and that explains the philosophy behind the measures that are contained in section 50, subsection 3, and 51, subsection 3. If we could look very briefly at Benjamin, which is in the Respondent's bundle.
Do you mean supplementary bundle?
Yes, Respondent supplementary bundle. I apologize, my lord. And this is I may be taking your lordships where we don't need to go again, but page 45. Sorry, I apologize, my lord. I think that's the wrong page.
45 is mitigation of damage.
Yes, is the mitigation. Yes, that is, the rules of mitigation are closely associated. And then at page 1200, which is at page 49, if your lordships have page 49 of the supplemental bundle, at the very top paragraph, if I could ask your lordships to read that paragraph. So, staying within this bundle, if I could ask your lordships to turn to page 16.
Yes, I mean, this principle
Yes.
of which he's speaking is the principle set out by Mr. Justice Toulson in the quote on the page before.
Yes, yes, which and indeed he says pretty much the same in Bungie and Nidera as Lord Toulson.
Yes, you're moving on to?
Yes, I was going to move on to page 16.
16.
16:16. Now, this is the celebrated decision of Mr. Justice Oliver and Radford and de Froberville, which I accept would not appear to be directly relevant to this case, but he does deal with the intimate relationship between measure of damages and mitigation. This judgment was called authoritative by Lord Gough in Alfred McAlpine, and something that commended his respectful admiration. The facts of the case involved the measure of damages for the defendant's failure to build a wall, namely whether it was the reduction in the value of the land in whose favor the wall was to be built, or the actual cost of building it. And Mr. Justice Oliver held it was the actual cost of building it on the facts of that case. But his statements of principle go wider, and they start at page 26, my lords. So in the passage, it's the paragraph just above E. And if I could ask your lordships to read that paragraph just up to the letter A on the next page, just up to the end of the last sentence, if I may.
Is this the "as it seems to me" paragraph?
Yes, yes, my lord.
Thank you.
So the points one gets from that is that although technically measure of damages and mitigation may be different, they are often, particularly in contract cases, mirror images of each other. And in particular, just above the letter H, His Lordship says that it may be that the very commodity is immediately and readily available from other sources, in which case his loss is to be measured by the cost of obtaining it in the nearest available market. We say the same applies. That's looking at the breach by the seller. The same applies when there's a breach by the buyer. He has the commodity in his hands, and it can be the value of that commodity can be measured by the price that can be obtained in the nearest market. So the question always is, as Mr. Justice Oliver says at the bottom of page 26, what sum would be reasonably required by him to mitigate by putting himself into that position. And it's important.
Yes, it's interesting. I mean, he emphasises further up the paragraph in the second sentence. He emphasised the reference to his particular circumstances, ascertaining what he has lost by the breach. So you're encouraged to look at the particular facts.
Yes. And then His Lordship reverts to this a little later on at page 39 of this bundle.
39?
39, my lord, just above the letter G. And His Lordship says, and he's discussing the date of breach rule. And you'll see at the letter G, he says, that, however, is not a universal principle, and the rationale behind it appears to me to lie in the inquiry at what date would the plaintiff reasonably have been expected to mitigate the damages by seeking an alternative to performance of the contractual obligation. In contracts for the sale of goods, for instance, where there is an available market, the date of non-delivery is generally the appropriate date because it is open to the plaintiff to mitigate by going into the market immediately. Where there is no readily available market, a later date may be appropriate.
And here in this particular contract, we are directed, though, to the date of default, are we?
Yes.
Yes.
Yes. But I don't take
Well, I
this
suppose
for the
the
date.
arbitrator could choose the alternative sale from subclause A
Yes.
as a fairer outcome
Yes.
in circumstances if there was a good reason for a delayed sale.
Yes.
And the market, if you're a seller, fell after the date of breach. And there are all sorts of situations in which the court finds that the breach date isn't most appropriate, and presumably arbitrators can do just the same.
Well, what the arbitrators did is, Madeline Jr. will correct me, I think Viterra declared default on, I think, the 9th of November, but the arbitrators fixed the 2nd of February 2018 as the date of default.
Because that was the first time the sellers
That's right.
had the capacity to sell.
That's right.
Yes.
And that again emphasizes the intimate connection between the subclause A measure and the subclause C measure.
Yeah.
And this analysis is picked up in the Golden Victory. If your lordships will bear with me, I will just... It's the wrong one. Can I give you this? I'm just going to clear my decks. And we're back to the electronic bundle, and it's page 660. So at page 660, paragraph 79, this is in the speech of Lord Brown. He quotes section 51.3, which is the non-delivery section, which mirrors the non-acceptance section of 50, subsection 3. And then at page 661, Lord Brown says, right at the top, but the rule is by no means confined to the sale of goods context, and as Lord Bingham explains, has been applied by analogy to a variety of other situations. Essentially, it applies whenever there is an available market for whatever has been lost, and its explanation is that the injured party should ordinarily go out into that market to make a substitute contract to mitigate and generally thereby crystallize his loss. Market prices move both up and down, as my Lord Legate pointed out. And at paragraph 80, the rule is easy to apply where, for example, goods or shares are traded. If the seller who is injured by non-acceptance, he must, as soon as possible, resell the goods or shares at the then available market price. If the buyer, he must similarly buy in substitute goods or shares. And just above the letter E, Lord Brown refers to Radford and de Faubreville, and refers to the much-quoted judgment of Mr. Justice Oliver, and the relevant passage is there right at the bottom of that quote. At what date could the plaintiff reasonably have been expected to mitigate the damages? And we're not concerned so much with date, but it's the focus on mitigation that is important. as regards the passage that I referred your lordships to in Radford, at letter F, Lord Brown approves Dodd Properties in Canterbury. He quotes from that judgment. And if we turn over to page 662, he quotes with approval Lord Justice McGow's approval of the judgment of Oliver J. as to the relationship between the duty to mitigate and the measure. And I'm now proposed to take your lordships to the last authority, and I'm almost finished on.
I don't know if you've looked, there's an article by Mr. Kramer called There is no breach date rule, which I saw was cited in the Benjamin footnote. It's a very good explanation of this whole area.
We'll probably look at it overnight.
It's also spelt out in his book on contract damages. Which,
yes, which we do have. So
well, I don't think you have put it actually in the bundles, but it's rather helpful too.
Yes. So the So this was an FOB case, and after goods had been shipped.
So which case are we on?
Sorry, I apologize. Page 581. 581.
Napier and Dexter's, yes.
So it's the electronic bundle, page 581.
Napier. Oh, yes, we're going to have Napier.
So we see, so 581 is where we see the judgment. This was an FOB London sale, and the holding was that after the seller had irrevocably committed to the shipment of the appropriated goods from London to Hamburg, the question became, do we take the London price or the Hamburg price? And just give me the page. And we see this at page 583, second column. So this is obiter. This is undoubtedly obiter because he found right on the middle of the page at page 583, right-hand column. On that ground, I hold that the arbitrator's award that the price is due is right in law. So the sellers were entitled to recover the price. And then he says, two other points that have been argued do not arise by reason of that finding, and I will only mention them. The first point is whether if the price were not recoverable, which of two measure of damages is the proper measure of damages. That matter has been argued before me, and it is open to both parties if it is thought elsewhere that the decisions of the arbitrator and myself are wrong as to recoverability of the price. If I had to decide it, I think I should have decided without doubt that the proper measure of damages is the Hamburg measure of damages, the larger sum, and for this reason, that it seems to me that the goods, when taken on board this ship, nominated by the buyers, were irrevocably committed, if I may use that expression, to the voyage to Hamburg. So this was appropriated goods put on a ship headed for Hamburg. And the question was, do you use the London price or the Hamburg price? And he said that it has to be the Hamburg price because those goods have been irrevocably committed to Hamburg. And then he says, and that the proper measure is the difference in price they would realize there.
Yeah.
So, my lords, we say that the weight of authority, to the extent this court needs authority, is consisting of the caloric, the Eurometal, and Napier and Dexter's, favors us. There is no authority that supports the Court of Appeal's construction or my learned friend's case. And we say, for those reasons, that you should allow the cross appeal. Now, I see we're almost at 4 o'clock. Might it be better if I start with my response tomorrow morning?
Yes, I think we've reached a natural point to adjourn. Very well. We'll adjourn now and resume at 10:30 tomorrow morning.